Good evening, good morning, and good night. So my name is Laurent, with my colleague Anna Maria Urbanova. Today we'll have a match between two teams who are on both sides of the world, morning, evening, and for us in Europe night. So now the floor is for Miss Urbanova.
Thank you very much, and good day, everyone. Good morning to Suva, and good evening to London, Ontario. Best wishes to the two teams that have joined and that have qualified for quarterfinals for the Hague Inter-University Law Debate Tournament 2024. Today's debate is part of the quarterfinal round, which is working with the topic of disinformation in law. This topic and the debate statement in particular are also part of the collaboration with the project of the Jean Monnet Grant, which is helmed by Dr. Garrido Munoz and Dr. Kostukiewicz. So there will be also a certain recognition for the matches of the quarterfinals afterwards in the final week. But specifically for today's debate, being part of the disinformation and law theme of this round, the teams will debate on the topic whether or not those who engage in intentional dissemination of disinformation via social media or media outlets should be held criminally liable. So the two teams have received the topic 7 days in advance. And as usual, we'll find out which positions will be defended by which side shortly after the introductions. And without further ado, I would like to pass the floor to University of South Pacific. Starting with Ms. Prakash. The floor is yours.
Greetings to all. As Ahmed mentioned, my name is Bishar Shani Prakash from the University of South Pacific, and just simply all the best to everyone. We have all have worked hard, so we'll just give our level best. Thank you so much. Take care.
Thank you and welcome. Now passing the floor to University of Western Ontario, starting with Mr. Spitsky. The floor is yours.
Hello, my name is Daniel Swirsky. I am a just finished first year student at the University of Western Ontario Law School, and I'm very excited for this debate.
Thank you and welcome. Now passing the floor back to University of South Pacific, Mr. Permal, the floor is yours.
Thank you. My name is Varunesh Parmal. It's an honor being and participating in this debate, especially in the quarterfinals. So all the best to the teams for making it out here, all the team members, and good luck.
Thank you. From University of Western Ontario, Mr. Hewitt.
Hi, everyone. I'm Papa Hewitt. I'm a second year student at the University of Western Ontario. Really looking forward to today's match and a really interesting topic. Thank you.
Your microphone, Anna Maria.
Oh, my apologies. I was saying from University of South Pacific, Ms. Lal, the floor is yours.
Thank you. Bulavanaka, everyone. I'm Kaya. I am a third-year law and economics student with USB. Super excited to be here today, and good luck to everyone.
Thank you, and welcome again. From University of Western Ontario, Ms. Igidi.
Hello, everyone. My name is Whitney Agidi. I just finished my first year at the University of Western Ontario. I'm looking forward to debating our friends from Fiji today. Best of luck, everyone.
Thank you very much and welcome. So, as always, in a short while, you will see the wheel for the allocation of positions. If I can just ask you to give me a confirmation and that indeed the wheel is visible to you.
Yes.
All right, thank you very much. So, as always, 4 possibilities, 2 possibilities for each team. All right, for today's debate, it will be the University of South Pacific, joining us from Suva, Fiji, that will be arguing in favor of the motion that those who engage in intentional dissemination of disinformation via social media or media outlets should be held criminally liable. and it will be the debate team of the University of Western Ontario that will argue against this motion and thus that they should not be held criminally liable. You now have 5 minutes to finalize your preparations. Feel free to close your cameras, and afterwards it will be the team of University of South Pacific that will start. Thank you, everyone. The time for your final preparation is now over. We'll be starting with the opening statements. First, the floor is with the team in favor, and the team of University of South Pacific. You now have 4 minutes.
May I confirm that I'm audible, please?
You are.
Thank you. The old adage, do the crime, do the time, is a poignant reminder that every action has a consequence. If you commit a crime, then you must serve the time that you are sentenced to. Greetings to the honorable judges, colleagues, and audience members. We affirm that individuals who engage in intentional dissemination of disinformation via social media or media outlets should be held criminally liable. We advance the following legal arguments. I argue that intentional dissemination has adverse impacts on our communities. Thus, its criminalization will have a deterrent effect and ensure accountability from the perpetrator. Varunesh discusses how criminalization allows for greater enforcement and accessibility to justice, and Visha will further explore the risks to public safety. As per the European Commission's high-level expert group on fake news and online disinformation, disinformation refers to, and I quote, all forms of false, inaccurate, or misleading information designed, presented, and promoted to intentionally cause public harm or profit, unquote. This definition has gained traction and application by both national and international bodies, including inter alia, the European Commission, and the Government of Denmark, emphasizing the severity of this issue. The impact of intentional dissemination can be problematic, having wide-reaching implications because it can significantly influence the knowledge and perceptions of the recipients of disinformation. For instance, segments of the global population exercised high health risk behaviors at the height of the COVID-19 pandemic due to the disinformation circulated on social media platforms. According to the peer-reviewed journal Vaccine, the self-reported likelihood of vaccination in the United States declined sharply from 74% to just 56% within a single year. The article blamed social media for disinformation, for influencing public mistrust and vaccine hesitancy. Another instance where intentional disinformation was harmful was in Myanmar. Here, fabricated stories about a massacre and rape was circulated via Facebook, inciting violence and genocide against the Rohingya people. The severity of the events had international repercussions, culminating in the government of Gambia bringing an action against Myanmar in the International Court of Justice. These examples demonstrate the urgency to enact criminal offenses in statute to hold the disseminators of disinformation accountable for their actions. Legal precedents like Prosecutor and Popovich recognize the irreparable harm caused by disinformation, where Guerrero intentionally disseminated misleading information to a news outlet. This assisted the joint criminal enterprise that aimed to remove the Muslim population from Srebrenica. In this case, the tribunal held that the purpose of disseminating falsehood was not innocent, as it intended to mislead. As such, Guerrero was imprisoned for 5 years. Some states have also started implementing legislation that criminalizes aspects of intentional disinformation. For instance, Denmark amended their penal code to criminalize disinformation dissemination that aids or enables a foreign state actor to influence public opinion. Similarly, Section 191 of the Criminal Code in Greece criminalizes disinformation if it damages the country's economy, tourism, defense capacity, or international relations. These examples demonstrate that criminalizing aspects of intentional disinformation is possible without undermining an individual's freedom to express themselves. To conclude, criminal sanctions will ensure the accountability of individuals who perpetrate these serious crimes. These individuals must understand that there are repercussions for their actions, and if you commit the crime, you must be prepared to do the time. Thank you.
Thank you. We have now heard the opening statement in the favor position. Now for the position against. University of Western Ontario's debate team, you have 4 minutes.
Lovely. Am I audible?
You are.
All right. And all right, great. I'm audible, visible. Lovely. Okay.
Yes.
Starting in 3, 2, 1. A Zambian media organization that published a false story on police corruption, an Indian woman who posted offensive comments on Facebook regarding a political leader, and a Canadian man who circulated a Holocaust denying pamphlet. Despite the falsity, the obscenity of these situations, the time-tested question of criminal liability for disinformation has been answered. The High Court of Zambia in Chimpanzee v. and the People, the Supreme Court of India in Shreya Singhal v. the Union of India, and the Supreme Court of Canada in R. and Sundell all struck down criminal provisions on disinformation, protecting freedom of speech, even when that speech is untrue or offensive. In response to the urgency of disinformation, it is imperative that our approach is guided by the commitment to freedom of expression, justice, and proportionality, rather than reactionary measures that could lead to overreach and life-changing sanctions such as incarceration. Good evening to our judges, and good afternoon to my colleagues at the University of South Pacific. My teammates Whitney, Tom, and I are pleased to be here today to discuss this topic with you. Today, we'll be arguing that those who engage in intentional dissemination of disinformation via social media outlets should not be held criminally liable. We afford three main arguments throughout this debate. Firstly, I will argue that criminal liability for disinformation is inherently subject to challenges in definition and enforcement. Secondly, my colleague Whitney will argue that criminal liability for disinformation violates the right to freedom of speech. Lastly, my colleague Tom will argue that there are alternatives to deal with disinformation that are more effective and less intrusive. So moving on to our first argument. Regardless of what criminal legal framework is adopted to govern disinformation, certain issues will inevitably arise, as outlined by Czech constitutional law scholar Han Kurdna. Firstly, to restrict disinformation, there must be definition of what is meant by disinformation and information as in the truth. This is because one of the basic principles of criminal law, known as the principle of legality, is that a provision must be sufficiently specific as to clearly signal legal and illegal behavior to the public. Otherwise, it is considered vague and thus unconstitutional. Unlike what Pro states in their submissions, there's no single internationally accepted definition of disinformation, as stated by the UN Special Rapporteur on Freedom of Opinion and Expression. Rather, there are competing international and domestic definitions, some of which require intent to deceive and some do not. This vagueness means individuals do not know what criminal is and what is not. Similarly, the term information is vague. It is often unclear to what extent it is true or false, especially given value judgments. And so any attempt to distinguish information from disinformation through criminal rulings or truth authority will fail, since the criminal code cannot functionally define all truths. As such, a chilling effect on freedom of speech is likely to arise. For instance, when Germany implemented laws against COVID-19 disinformation in 2020, early evaluations and studies showed that social media companies were risk-averse and curtailed and censored legitimate material. Secondly, to punish disinformation, there must be intention beyond a reasonable doubt, aka mens rea. In many criminal law jurisdictions, such as Canada and the United States, there's a rebuttable presumption that everyone intends uptaking of their actions, which is easily recognizable in crimes such as murder, but not in the crime that they're defining on Pro. However, in many instances, it's really hard to define false information. Author's intent is not obvious. There are a lot of gray areas that exist. And so, the criminal law provision on disinformation is likely to be inoperable and rarely used. This is bad for two reasons. One, public resources are wasted on criminal enforcement, but two, there are negative repercussions on public trust fostered from having provisions that poorly police people. Lastly, there are many enforcement problems, such as the fact that most information can be planted without leaving traces to its origin, meaning that those who disseminate might not be aware of its falseness. And information on social networks are global in nature, which creates jurisdictional issues. In conclusion, this argument proves that there's a lot of issues that exist in enforcing this. That means people who are innocent are likely to be tried in a way that they should not be.
Thank you very much. We have now heard the opening statements from both teams. We'll proceed with the rebuttals, starting with the first rebuttal, this time in the position in favor. University of the South Pacific, you have 2 minutes.
Distinguished teams, judges, and audience members, I commend my colleague in the opposing team for presenting his view. However, our team under the affirmative stance disagree with the points of not criminalizing the dissemination of disinformation through social media and media outlets. The first speaker had mentioned that we should not endorse life-changing incarceration for people who engage in disinformation. What about the life-changing trauma inflicted upon the people? The freedom of expression should end when someone else's life comes into play. Additionally, I would like to rebut their argument on the basis of a greater enforcement and accessibility of justice. While my learned opposing team may argue there are other avenues such as civil actions available, These may not always be time efficient and accessible to regular citizens due to its costly and protracted nature. Intentional dissemination of disinformation can have far-reaching and serious consequences, such as undermining election processes, inciting violence, and distorting public opinion. Criminalizing such behavior sends a strong signal that society takes these acts seriously and deters malicious actors from engaging in such conduct. Criminalizing dissemination of disinformation empowers states to enforce measures through laws and regulations, thereby also enabling the state to actively prosecute perpetrators. In the case of USA versus Mackey, a social media influencer, Douglas Mackey, conspired to spread disinformation, including fraudulent messages and advertisements to interfere with potential voters in the 2016 presidential elections. Following investigation by the Federal Bureau of Investigation, a U.S. attorney prosecuted the case, resulting in 7 months imprisonment for Mackey. This case underscores the significance of criminalizing disinformation, which allows states to take proactive measures to investigate and prosecute such offenders. That is my submission. Thank you very much.
Thank you very much. We'll now hear the first rebuttal in the against position. Team of University of Western Ontario, you have 2 minutes.
Before we begin, may I please confirm that I am both visible and audible?
You are.
Excellent. Thank you. I'd like to thank our friends for their argument, which I'll summarize as being that the use of criminal law is a necessary means to address the intentional spreading of disinformation. However, I must respectfully disagree because on interpretation, this is an overly broad characterization of the current jurisprudence regarding the limitation of internationally protected rights, especially where there are alternative means to address this issue. For instance, my friend Kaya outlined the importance of addressing disinformation during the pandemic. What was missed is that states are already addressing this issue, not relying on criminalization, as made evident by the creation of the WHO pandemic instrument and amendments to the international health regulations to specifically respond to disinformation in timely information sharing. You see, under international law, the right to freedom of expression is protected by Article 19 of the ICCPR. Although subsection 3 permits limitations on these rights, these circumstances are very narrow. It is usually done where the law is precise and clear and there is a legitimate aim, such as the protection of rights, or in pursuit of national security and public order. In this case, not only would the provisions inherently be unclear and imprecise, but none of the aforementioned aims are applicable or legitimate because the goals of protecting rights, public order, and national security, in most instances, are already captured under existing, well-defined areas of law, such as the areas of fraud, defamation, and sedition. And it seems that courts would agree with us. For instance, the Supreme Court of Canada struck down Section 66A of the Information Technology Act as excessively and disproportionately interfering with the right to freedom of expression, where there are less arbitrary and fair ways to combat disinformation. Thus, it is clear that in theory and practice, criminalizing the intentional spreading of disinformation would be an unjustifiable limit on the freedom of expression. Thank you.
Thank you very much. We'll now hear the second rebuttal in the favor position. University of South Pacific, you have 2 minutes.
Firstly, just to confirm that I'm audible.
You are.
Thank you. I would like to thank my counterpart colleagues for their argument. However, I will respectfully decline. As you have mentioned, Article 19 of ICCPR, there are justifications of limiting freedom of speech and expression. And as the first speaker has mentioned, that it infringes on the freedom of expression. There's 2 parts to it. First, we have to impose the freedom of expression and speech. Second, the ones that limit it must be justifiable, and they have 3-part test. These 3-part test is regarding proportional, that whatever provision you're limiting must be based on validation and not broadly discussed. The guideline itself says that it must not be a broad discussion, it must be for a particular purpose. So therefore, this just goes to show that the broad definition argument is not valid. And freedom of speech, when there are impositions, they're basically for justifiable limitation, as per Article 19 as suggested you say so. Therefore, countries have used these guidelines. Example, Fiji Constitution, the limitation they placed are based on those guidelines as such. And it's also arguable that it's important to criminalize, because on the cases regarding heinous crimes, we need to criminalize these cases. For instance, Manipur case, whereby known as in the Manipur Tribunal Forum versus the state of Manipur. In the case, due to a fake news of a woman being raped, alleged war between the two tribes that led to 160 deaths, rape, and murder of many children, and destructions of buildings and places. In such cases, we must enforce criminalization of disinformation, because one fake news had led to such severity of situations. And as such, in order to protect for public safety and well-being, criminalization must be accounted, especially the group of minorities, because according to a UN report, it stated the majority of the hate crime speech in social media, 70% minority members have been affected. This just goes to show heinous crimes and the safety of public, we must enforce criminalization of disinformation. Thank you.
Thank you very much. Now for the second rebuttal in the against position. Team of University of Western Ontario, you have 2 minutes.
Can I please just confirm that I'm both audible and visible?
You are.
Thank you. So we'd like to respectfully disagree with the argument from our colleagues that the use of criminal liability is the best approach to addressing intentional dissemination of disinformation. Rather, the work of leading experts suggests that there are much more effective approaches to addressing these serious concerns. So our colleagues from the University of South Pacific cited the 2018 high-level expert group report on fake news and online disinformation conducted by the European Commission, which brought together a collection of the leading minds on this issue. The group suggested key areas for intervention to target disinformation, including increasing transparency, promoting media literacy, empowering journalists and users, safeguarding the diversity of news media, and continuing research on the efficacy of interventions. None of their recommendations suggested criminal liability, and all of them addressed disinformation in more effective and thorough ways. Moreover, private sector actors, such as social media giants, have the authority to enforce content moderation policy and a greater capacity to deal with disinformation. In a 2022 study, the Harvard Kennedy School examined groups repeatedly sharing disinformation on Facebook. The researchers observed a significant reduction in engagement per post of 16 to 31% because of Facebook's policy responses to disinformation. And finally, courts around the world already routinely impose civil liability for a false statement of facts based on provisions that are
Your audio cut off at 35 seconds. Mr. Hewitt. All right. There are sometimes occurrences where technical glitches happen. In those
provision
situations,
for disinformation
Mr. Hewitt.
and better address. Yep.
Mr. Hewitt, apologies, but your audio cut off at around 30th second. So from the provision, if you can remember which that part was, whenever you're comfortable, I will restart the timer. For the judges, please disregard the technical difficulty as much as possible.
Okay, great. Am I good to resume?
You should be. I will just kindly ask everyone else to turn off your cameras.
And just to note, I think, Thomas, you're starting to talk about the alternatives, or you start listing out like what alternative legal mechanisms exist.
Okay, perfect.
All right, whenever you're ready, you have 30 seconds.
Okay. So finally, courts around the world are already routinely imposing civil liability for a false statement of facts based on provisions that are consistent with the free speech guarantee. So countries including Canada, the US, Australia, and New Zealand have implemented civil laws addressing defamation and other speech torts. So for instance, in the United States, Alex Jones was ordered to pay the families of the Sandy Hook mass shooting victims $1.4 billion in damages for intentionally and maliciously promoting dangerous conspiracy theories about the tragedy through social media. These approaches are more precisely defined, and given all of these considerations, criminal liability is redundant. Thank you.
Thank you very much. This concludes the rebuttal part of the debate. We'll proceed with the conclusions. Starting with the team in favor, University of South Pacific's team, you have 2 minutes.
Ladies and gentlemen, thank you for your attention. As our team had affirmatively argued through a closer analysis of conventions, case laws, and policies, we strongly advocate for criminalizing intentional dissemination of disinformation through social media and other media outlets for the following reasons. Firstly, it promotes accountability and responsibility. Secondly, it allows for greater enforcement and accessibility of justice. And thirdly, it ensures public safety and well-being. As the first speaker highlighted, intentional dissemination of disinformation can have far-reaching and devastating consequences, especially for public health. This was exemplified by vaccine hesitancy influenced through social media during the COVID-19 pandemic. Moreover, disinformation also has the tendency to incite racial violence and tensions, as demonstrated in Myanmar against the Rohingya, and India's Manipur case, where tensions were escalated between the Meitei and the Kuki tribe, leading to mass riots and deaths. Additionally, cases such as USA versus Mackey and Prosecutor versus Popovich recognize the significance of harm that disinformation poses upon democracy by using it to influence political and racially motivated agendas. Criminalizing disinformation is the way forward, and nations such as Denmark and Greece have recognized this and acknowledged this by codifying such provisions, thereby enabling investigation and prosecution of offenders, especially when disinformation can damage economies, tourism, defense capacity, and international relations. Our learned colleague in the rebuttals mentioned the Sandy Hook's case. Till date, the families have not received their payment in civil cases, which shows that sometimes the system can be played around with. They are still waiting for justice. Therefore, in light of the above, it is crucial to acknowledge the grave threats posed by the spread of disinformation and start taking decisive criminal actions to address and mitigate it. Thank you.
Thank you very much. Now for the position in against University of Western Ontario, you have 2 minutes for your conclusion.
Lovely. Am I audible?
You are.
All right. Well, I'm going to be starting in 3, 2. I want to thank my opponents for their arguments in this debate. The pro side had several key burdens. Firstly, proving that disinformation is a problem and has far-reaching consequences is only a quarter of what pro had to prove. Just because states have implemented laws to fight disinformation as a problem does not mean that it is just or effective. Secondly, the burden was to prove that criminalization can solve disinformation. We've explained to you that there are enforcement problems like anonymity, jurisdictional issues that make this law unable to solve disinformation. It's also unclear why deterrence will work, especially since disinformation is done on ideological lines. People believe in anti-vaxxing, and they believe it to be true, so you're criminalizing people's true beliefs. Also, American law professor Rebecca Helm and Hitoshi Nasu noted that there's a strong potential that particular groups will feel that news representing their viewpoints is specifically targeted and identified as false, and therefore they'll feel prosecuted and therefore will be reinvigorated in their beliefs. When you tell conspiracy theorists that their beliefs are false and you criminalize them, it further reinforces their beliefs and makes them act out in more irrational ways. The third burden they had to prove was that criminalization solvency produces more good than harm. I've explained to you that there are chilling effects and the prosecution of innocence by virtue of the abstractness of the law, and how it's hard to connect the act to the consequence. And fourth, they had to prove that criminalization is the best solution compared to alternatives. We explained to you that there are alternatives that do not unjustifiably limit the freedom of expression, and that there are alternatives that deal with disinformation specifically. Like for Myanmar, you could use hate speech laws. You could use things like defamation in those cases, false representations and contracts and torts. Their law is redundant. Ultimately, the pro side failed to prove that this is consistent with the rights that exist in international law, the exemptions that were afforded by the United Nations, human rights codes, and everything else. And therefore, even if you believe that they proved every other point, it still falls. I want to end this debate in a quote. The first principle of a free society is an untrammeled flow of words in an open form. Freedom of speech is a right that should remain absolute. That fails on pro side.
Thank you very much. Thank you very much, everyone. This concludes the debate for today's round of quarterfinals in the theme of disinformation and law. I just want to congratulate all of you on the topic, on the preparation, on getting this far in the competition. I also want to thank the 3 judges that will be independently reviewing the debate and providing the scores to the 2 teams. I really hope, just on the organization side, if you can disregard the technical difficulties that might have come up during the debate. I'm sure it will be already quite difficult to judge on the merit and on the strength of the arguments of the 2 teams. So just want to thank you again to the judges as well as to the teams. And as we will be waiting for the feedback from the judges, it is now time also to do a short feedback within the debate session itself. Perhaps starting with the University of South Pacific. Ms. Lal, how did you find the debate, the topic?
Yeah, I really enjoyed this topic. I think the topic itself was very interesting for like 2 major aspects. I think first is I'm currently taking a criminal law course, so it's really nice seeing how my theoretical knowledge like plays into. I think especially for the negative side, there were a lot of areas which I could implement, so that was interesting, and also just being able to diversify my criminal law knowledge. That was really nice. I think secondly is seeing how disinformation has evolved over the years. So by no means is disinformation a new concept, but it continues to evolve like law and society. So it's interesting to see how nations have, tried to adapt along with it. I think both teams did really well today, and I really enjoyed the debate. So thank you so much.
Thank you so much, Ms. Law. Thank you for sharing. Now, with the same question for perhaps Ms. Igidi from University of Western Ontario. How did you find the debate and the topic?
Hi. First and foremost, I just wanted to say it was a pleasure debating my friends today. It was really, really interesting. I found this to be a really, again, interesting and relevant topic. As was just noted, disinformation has always been around, but the magnitude of such is being felt very much so, considering the technology we have today, and especially after the pandemic as well. So I think intuitively reading the question for this week, some people probably had strong opinions going in, but nevertheless, we had to be prepared to defend either side. And so, yeah, it definitely was an interesting topic. Thank you so much.
Thank you for sharing, Ms. Igidi. What about you, Mr. Permal? How did you find the debate, the topic, and perhaps did you already prepare by watching the previous matches of your opponents prior to the debate?
Oh, of course, most certainly. Yeah, it's very good to learn the opposition, their caliber, their qualities, so that we can up our game as well. And we definitely upped our game for this match, given the caliber of University of Western Ontario. This was a very interesting debate because, as you know, there is disinformation all around us. But delving deeper into the legalities and how it can fall both sides was definitely I found really fascinating. And yeah, thank you so much for the opportunity in being in this debate. Thank you.
Thank you, Mr. Permal. Mr. Swirsky, how did you find the debate and the preparation? Did you perhaps already also look into the debates, prior debates of your opponents?
Yeah, absolutely. Yeah, we did everything possible to get ready. I really enjoyed this topic. I think this was actually the one I enjoyed the most. I think that there was a lot of, I like it a lot since it's a very notably emerging field of law. And as mentioned by our friends, that disinformation has existed for a while, but the nature of disinformation law has not necessarily fully caught up to that. So I really enjoyed prepping both sides. I enjoyed theorizing and crafting the arguments, trying to predict what both sides are likely to say. I thought it was a very fruitful debate, and we heard a lot of everything of what we were planning to say on the pro side. So I think everyone did an excellent job.
Thank you for sharing, Mr. Swirsky. Ms. Prakash, how did you find the debate, the topic, and perhaps what other areas of your studies perhaps have you seen connected to the area of disinformation?
Thank you, madam. Firstly, regarding this topic, I personally did enjoy this topic, and as upon my researching on it, it's just like I got to learn more about this information. Like when I initially read the topic, it's just I knew basic information, but when I went to the depth of its legality, how social is connected, even I was reading how psychology was connected with law and everything. Like there was so many information like for 2 minutes if it had been like a 10-minute debate, I'm sure there would be a more like heated proper more arguments because there was so many informations regarding it and it was so interesting. And as for my topic, of course I have done criminal law myself, so yeah, as what Kaya has mentioned, so I was kind of preview of the legality. And just recently I had to do one like a major assignment regarding freedom of expression and it's a limitation, and if the limitations are imposed, then what are justifiable limitations, the three-part test. So I was like, okay, yeah, okay, I know about this, I got this. So I was like in those moments, like I kind of like use that information to actually understand how to actually navigate through my rebuttals, because there were so many dynamics towards that study I've done. So like it was very fruitful for me. If I must say, it was like a good coincidence from one after the other. So yeah, it was a very good debate. And I truly enjoy my counterpart colleagues with their arguments. It was truly like I was enjoying listening to you guys as well. It was like wow, it's like interesting, like how they articulate, the way you have like structured your arguments. It's like I every time I have tried to learn something from my counterpart colleagues, and these are some of the things I learned from you guys, like the speech, especially Mr. Thomas, when there was like that break, but he was so calm and collected. I'm more the person who gets panicked a lot, so I kind of learned that from Mr. Thomas, like be calm and composed. That's why I really commend my counterpart colleagues for that. Thank you.
Thank you. Thank you, Ms. Prakash. Perhaps Mr. Hewitt, if you can follow up as well, maybe in reaction also to what was shared, and also your own experience. How did you find the debate topic, and what areas of your studies have you seen this information play important role in?
Yeah, for sure. First of all, thank you so much for saying that. That's very nice. I did not feel calm or collected, so it's nice for you to say that. It was really enjoyable experience. To be honest, it wasn't an area that I've touched on much in my studies. I think a lot of my focus has been sort of more corporate, international, sort of private international law. So this is sort of an interesting way to look at it. And criminal isn't an area of focus, so it was really fun to sort of peel back some of those layers and get a taste of the arguments on both sides. It was one of the ones where it was really fun to the more you researched one argument for the pro or the argument for the con, it kind of strengthened the counter. It was really sort of fun opportunity to really delve into those. So I really enjoyed that. And it was really great listening to the team from the University of South Pacific. A lot of really strong arguments, really sort of well laid out and well positioned. And it was really evident how much preparation had gone into it. So it was great to sort of have that back and forth and really get to enjoy it. So it was really great getting to meet you all and have this awesome opportunity.
Thank you for sharing. And just a final wrap up, a little bit of networking. You have already experienced the different areas throughout the previous debates. So perhaps for this one, a little bit of twist on it. I would just ask you individually, what are your plans, if you already know, or what is your anticipation for your next step in your career, be that academic or professional as practicing lawyers? So perhaps starting with Ms. Igiri, what do you anticipate that might come in the future for you?
Hi, yeah. I would say I'm still very open with my options, but I would like to do something in the realm of corporate law, specifically international commercial practice, where I'm able to look at cross-jurisdictional transactions. So it's been a real pleasure debating some of the topics that we've had this year, especially related to IP, because I'm really interested in that.
Well, perhaps that might be also a common topic with your fellow participants in this debate. Ms. Lal, would that be the case? So what are your plans?
I think, like Miss Ikiti, I'm still also deciding. I have 2 more years left for my degree. I'm hoping to pursue masters straight after, and I'm really interested in arbitration. I think from the debate topic, I think match two, it's really gotten me really interested in the topic. So that could be a potential for me. So thank you so much, everyone.
Thank you for sharing. What about you, Ms. Prakash? What are your plans? Perhaps a similar topic area?
Okay, so for me, I'm kind of leaning on towards international environmental law. And yes, of course, arbitration. After I was doing that debate, I was kind of interested in it. I'm still trying to navigate where from those two I'm going to do, like specifically. And yes, of course, I will continue my studies, hopefully go to my master's as well. And that's my current plan. And thank you.
Hi, thank you for sharing. Mr. Hewitt, what are your plans? Maybe a commonality, environmental law might be in the future?
Sorry. I'm not sure if my camera is on or not, but my computer is really not working today. So my plans are to go into, similar to Whitney, sort of international commercial law. So I actually start my summer internship at one of the major Canadian corporate law firms on Monday. So that's coming up very quickly, which I'm really looking forward to, where I'll be doing a mixture of mergers and acquisitions with mostly an international focus, as well as cross-border bankruptcy and restructuring deals. So it's a really interesting mix of different sort of commercial aspects, and really looking forward to it.
Oh, congratulations on the next step starting. What about you, Mr. Permal? What are your plans for the future?
Well, my current plans are being in connection with my USP teammates because they'll be going to arbitration, so big money there. But jokes aside, currently I'm working at the moment, so we mostly handle consumer-related prosecution. So that has really gotten me interested in criminal law. So I probably might dabble with that for a bit, and probably, after a few years, see where life takes me, learn, because as I said, our society is evolving. There's always a need for laws in different areas, AI, for example. So still thinking, and it's exciting prospects as well out there. Thank you.
Right. Well, thank you everyone for sharing. I don't want to repeat myself from each and every match, but I really hope that the experience has been good for you and that you stay in touch. It's always good to have connections across the not just the country, but across the continent, really, that you have matched throughout the competition. And perhaps, hopefully, you'll have also the possibility to travel to The Hague for the final week that will be happening in June. If you do so, do not hesitate to message us. We have a discount codes for the air tickets, so in collaboration with Air France and KLM. So definitely do let us know. And just
Ms.
once,
Ivanova,
yes,
sorry for interrupting you. Is it okay if you forward us some information regarding that? So
absolutely.
that we can. Thank you so much.
We'll do that, as well as the list for possible registrations for visits in the city for the final week. And there will be also a big reception for everyone, also including the sister competition that will be also concluding in the same week. And on that note, just congratulations, everyone, really. Good job. Already you have secured the spot for your successors for the next edition. Among the 32 spots that are in the competition, 16 are reserved for the teams that pass it to the final phase. And thus, without further ado, also my lamp, I think, has given up and went to sleep, as it is midnight in Europe. Just really, I
1
wish you all
a.m.
the best. Yes, just all the best for the rest of the day and for the rest of the week. And until the next time.
Thank you very much.
Thank you so
Thank you.
Thank you.
Thank you very much.
Thank you.
Day or night. Take care.
Thank you.
Thank you.
Bye-bye.
Bye.
Mm.